10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hello, my friends, and thank you so much for choosing to spend part of your Saturday evening with me. Today is February 24th, 2024, and welcome to another episode of You Just Can't Make This Up. How is everyone tonight? And in the vein of thinking in song lyrics, as you know I often do, first one who can name this tune. Hello, old friends. It's really good to see you once again. Songwriter, artist, title. Go. That's an easy one. I think you can get it. So tonight we are going to dissect and break down the defense motion to disqualify Michael Morrissey's office, the Norfolk DA, and sanction them in the Karen Reed case, as well as the opposition filed by the prosecution. What I find very interesting about this is that the defense motion had been impounded, correct? Am I in the twilight zone on this again? And then all of a sudden, it was unimpounded within the past few days. And the prosecution filed their opposition to this motion on February 15th. You may recall these motions were supposed to be heard, I think, on the 15th. And they came into court and they tried to adjourn it. And the court said no, which is rarely done because usually if something is consented to by both sides, the judge will allow it, but not in this case. So Monday, both sides are supposed to argue the motion to dismiss the indictment. However, I don't even know what day it is anymore. I think it was yesterday. The defense filed a motion asking for an adjournment on that motion that is supposed to be held on Monday at 2 p.m. To my knowledge, there is no decision on that motion yet. So they are likely going to have to appear. And they're likely going to have to either argue in person why that motion should be adjourned. And my guess is that because the 2E material was released from the feds to both sides, there may be some information in there that the defense would like to use in their argument. Their reply to the opposition was supposed to be put in yesterday. It was not. Instead, this motion was filed for an adjournment. So I don't know what's going to happen on Monday, but we're going to be here for it, all of us. And I know all you guys are going to be for it too. Be here for it too. I just want to see if anybody got that song. Hello, Peter Pranzo. Hey to all my amazing moderators, and thank you for keeping the chat classy tonight. As always, we welcome chatters in the chat, but we don't like foul language. We don't like trash talk, and we don't like personal attacks on anyone, including me, any other creators, the moderators, each other. We just don't allow it here. And we have the best moderators on YouTube, and you know it. Nope, not the sound of silence. It is not. Okay, I'll say it again for you. Hello, old friends. It's really good to see you once again. Let's see. Hello, Glare. No, Will, it's not Kendrick Lamar, unless he did a remake of it. Does nobody really know this? I'm surprised. I mean, I would play it for you, but then they would strike me. Dana Ferguson, thank you. It's Eric Clapton. It is Eric Clapton. Okay, we have a lot to get to tonight. And Turtle Boy is out of jail. Aiden Carney is out of jail, so he's going live with his show at 9. And we'd like to be out of here by then because I think he deserves for you to go watch him. And thank you, Brian, for coming in here with the 10 spot. Thanks, Brian. LTL True Crime, Melanie, always holding it down. Keep it classy. Free Karen Reed, thank you. Thank you, Magnolia Gypsy, for becoming a member. And Maureen Francis is always, always, always the first in with the super sticker. Thank you so much. We've got a lot to cover tonight, so let's get to it. The first thing that I want to pull up is what I feel to be the most important part of this motion. And it is so important that I'm going to read it to you. And I'm going to leave it on the screen because I think that this is super, super important. And I want everyone to keep this in mind while we go through this motion. And this is the Due Process Clause of the United States Constitution and the Massachusetts Declaration of Rights, which guarantee any defendant, not just Karen Read, the right to be prosecuted by a disinterested prosecutor. And that is quoted here in the motion on, I think it's page, I don't know, page, it doesn't really matter what page it is. I guess you guys have already, page 20. And it says as follows. And for those of you who are complaining that the cupcake logo is in the right side of the screen and you can't read the documents, I can't move it. That's just a StreamYard thing. That's where they put it. I don't have the option of where it goes. Just use your imagination. Or just try and read it while I'm scrolling. It's really, I can't do anything about that. Okay, here we go. Between the private life of the citizen and the public glare of criminal accusation stands the prosecutor. That state official has the power to employ the full machinery of the state in scrutinizing any given individual. Even if a defendant is ultimately acquitted, forced immersion in criminal investigation and adjudication is a wrenching disruption of everyday life. For this reason, we must have assurance that those who wield this power will be guided solely by their sense of public responsibility. One of the main arguments in this motion is going to be that Michael Morrissey has other interests here that are not only the prosecution of Karen Read. And we're going to go through a couple of those reasons. I'm not going to read the entire document to you because this one is 49 pages. The opposition is something like another 25 pages, and we'd be here for hours. So I'm going to cull for you the most important portions, and I'll just in my own words explain to you what the arguments are. And this is another very important piece of this motion. This is footnote 7, which follows the quote that I just read to you. In the same vein, United States Supreme Court Justice Robert H. Jackson observed, the prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. The prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard. Or he may go on with a public trial. If he obtains a conviction, the prosecutor can still make recommendations as to sentence, as to whether the prisoner should get probation or a suspended sentence, and after he is put away, as to whether he is a fit subject for parole. While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst. And the citation there is Jackson, the federal prosecutor, which was an address delivered at the second annual conference of the United States Attorneys in April of 1940. And those words are still true today. Keep in mind that the district attorney's position is an elected position. Michael Morrissey, I think, has been the district attorney since 2010, correct? And I think most of the time he's run unopposed. And a lot of people do not vote in non-presidential elections. And I suggest to you the importance of voting in these elections, because if candidates run unopposed, you get what you get. As the kids say, you get what you get and you don't get upset. Here now, we shall look at the defendant's motion for sanctions and for disqualification of the Norfolk County District Attorney and memorandum support thereof. We're not going to look at the memorandum. We're just going to look at the basic arguments and the reasons why Karen Read's team feels that the indictment should be dismissed because of the conflict, inappropriate behavior, misrepresentations of the district attorney in this case, as well as its misrepresentations and failure to notify the defense that there was a federal investigation ongoing into the investigation on the Karen Reed case. And then we're going to take a look and see what the prosecution has to say in its response, which we're going to have a little bit of fun with that. And listen, I'm not here. If you know me, you know me. I'm just going to say this one time, and then we're going to go on from here. Sometimes I agree with the defense. Sometimes I agree with the prosecution. Sometimes I agree with the plaintiff. Sometimes I agree with the defendant. But what I always am a believer in is the Constitution, procedure, and the rule of law. So this is not a neutral channel. You don't need to put in the comments that I'm not being neutral and that I'm supposed to be impartial. I don't care. I'm not supposed to be impartial. I'm not a judge. I'm sitting here as a YouTuber, legal commentator, and I've been an attorney for 30 years, and I'm coming to you based on my experience, and I'm going to have an opinion. I'm going to share it with you. I'm not a cupcake. That's what it says up there somewhere over here. I can't make everyone happy. I'm not a cupcake. So I'm going to share my opinions with you. And if that's what you're here for, great. If you don't like it, great. You can disagree with me. You can disagree with me in the comments respectfully, and I'll be happy to debate with you. But I won't do it on Twitter with a bunch of twits. So come for me in the comments. There's merch. All right. Thank you. Thank you. Somebody says that's why I like you. I appreciate that. It's not a neutral channel. So it just cracks me up when people say you're not being neutral. Okay. I don't need to be neutral. Do I? That's boring. Neutral is boring. There are other people who will give you neutral channels. They'll show you a slideshow montage and it'll be narrated by a robotic voice. And if that's what you're into, then certainly go watch that by all means. Not going to hurt my feelings. Okay. So the defendant is basing its motion, and the motion is for the court to sanction the prosecution for constitutional due process violations and for violations of ethical requirements imposed by the Massachusetts Rule of Professional Conduct and for egregious misrepresentations to the tribunal and to opposing counsel. Additionally, the defendant moves to disqualify the Norfolk County District Attorney because of his clear interest, other than the pursuit of justice, in the outcome of this prosecution. In further support of this motion, the defendant relies on the arguments below. To the person who thought that my cursor was a fly on their TV screen the other night, I apologize. So if anybody is freaking out that they think there's a fly on their screen, it's not. It's my cursor. It's what I use to scroll through the documents for you. So don't break your television and send me the bill. Okay. Here are the facts as stated briefly in defendant's motion. Defendant is charged with murder in the second degree in violation of statute, manslaughter while operating under the influence of alcohol in violation of statute, and leaving the scene of a personal injury. We know all of this. We've been through this many, many, many times. What we have not seen before, the defendant's counsel have asserted in court filings and in court arguments based on evidence both developed by the defendant and disclosed by the Commonwealth in discovery, including the analyses of John O'Keefe's phone and the phone of a civilian witness also present inside 34 Fairview Road. This is the first time I'm seeing that there was analysis of a civilian witness also inside 34 Fairview. Think about it. Who are the civilian witnesses? Brian Albert's not a civilian because he's law enforcement. Higgins is not a civilian because he's law enforcement. Did one of the kids in the house turn over their cell phone? Very interesting. But according to the analysis of both John O'Keefe's phone and this civilian's phone, defense is alleging that John O'Keefe had entered 34 Fairview, that he was attacked inside that residence by a person or persons also present there. That persons also present in the residence were aware that John O'Keefe had sustained injuries inside the home and participated in a cover-up of what happened. That other law enforcement officers, including a Massachusetts State Police trooper, Proctor, had participated in and furthered the cover-up of what happened to John O'Keefe inside 34 Fairview, including by planting incriminating evidence falsely implicating the defendant in John O'Keefe's death. As this court has explicitly noted, perhaps with understatement, this case has generated significant media attention locally and nationally. I'm going to submit to you internationally because I would like all of my international friends in the chat to raise a hand and tell me where you're watching from. I know there are a lot of you in Ireland, Scotland, other parts of the UK, Australia. This is not only nationwide, my friends. This is an international story. Okay? Will says it's Sarah Levinson's phone. Okay, we'll see. Interesting. Thank you. Who has written this? Somebody said this is the defense's motion. We're going to hear both sides tonight. The Commonwealth, you may recall, in June of 2023, filed a motion for a gag order. We see gag orders in other cases. I believe there's a gag order in the Koberger case, which is the Idaho 4 case. There may be a gag order in the Delphi case, which is Richard Allen's case. Don't quote me on this. I think there is, and that's why they got in trouble, because those photos got out. The Commonwealth moved for a gag order in June of 2023, and that gag order was denied. So the attorneys are allowed to speak to whoever they want to speak to. They can talk to the media. They can talk to anybody. They can talk to journalists. They can talk to reporters. There is no gag order in this case. Keep that in mind, because the prosecution, the Commonwealth, and their opposition to this is now going to ask for a gag order and some other things, which I have never, ever heard of before. So let's get there. So the Commonwealth, or the judge, denied the Commonwealth's motion for a gag order and said, hold on, let me just say here. Okay, they said in their motion, the Commonwealth said in their motion, we would like to prohibit defense counsel from being able to speak to the media. And we, if you grant that motion, we will also abide by that motion. And we will as well not talk to the media. We will not let law enforcement talk to the media. And we agree to be bound by that same order, Judge, if you grant that motion. And the judge said, no, I think that everyone can just, agree that they're going to adhere to the rules of professional responsibility as attorneys and officers of the court. And I don't need to make an order because, we don't even have a trial date yet. And that's what she said. So the motion is denied. And understand also that when you take the bar exam to become an attorney, a lot of people don't know that you also have to take an ethics test. So there's a bar exam, which is, when I took it a million years ago, was a 2-day test. One day was on, federal law, and the second day was only on New York law here in New York. And then you had to take separately an ethics test, which tests you on the code of professional responsibility, because as an officer of the court, you are held to a higher standard and you have to abide by these ethical rules. And of course, ethics are very important when you're a lawyer or a judge, and you are supposed to avoid the appearance, even the appearance of impropriety is against the rules. And if you violate the rules of professional responsibility, you can be sanctioned by the Bar Association, you can be suspended, you can be disbarred. It's a whole different proceeding. So keep that in mind as well. The Commonwealth, this is, again, I'm reading the document again, specifically contended that under the Massachusetts Rules of Professional Conduct, counsel is prohibited from making repeated extrajudicial statements that they know or reasonably should know have a substantial likelihood of materially prejudicing potential trial jurors or witnesses. The court rejected those contentions and specifically found that the statements and arguments attributed to the defense counsel can generally be characterized as responses to the accusations against the defendant and as pertaining to the theory of her defense, and that the statements are therefore permitted under the rules. So it was okay for Karen Read's lawyers to speak to the media. In that order, the court further cautioned all counsel that they are bound by the rules of professional conduct and therefore subject to the sanctions in place for violating them. This court specifically admonished, quote, in particular, counsel must be cognizant that statements commenting on the character, credibility, or reputation of a witness or conveying information which counsel knows or reasonably should know is likely to be inadmissible as evidence in trial are more likely than not to have a material prejudicial effect on the proceeding. Therefore, the Commonwealth's motion was denied. 25 days after the denial of that motion, Michael Morrissey, the district attorney of Norfolk County, disseminated to the media a video statement that he created, 5 minutes and 45 seconds in length, simultaneously also releasing a full transcript of the video statement to the media. In the video, District Attorney Morrissey, seated in front of a bookcase of volumes of Massachusetts state courts and opinions, directly addressed the camera, reading a statement that he acknowledged at the start is unprecedented. Instead of looking at the full transcript, which they're going to show right here, let's watch the video, shall we? Because you tell me if you think that this video is highly prejudicial to the defense. He states that it's unprecedented at the start. It's 5 minutes long, but I think it's worth watching again for those of you who haven't seen it, and even for those of you who have, because now we are going to look at this video and we're going to listen to what he's saying in this video, and with the understanding that it was 25 days after their motion for a gag order was denied. There were no reporters present. He videotaped this and then just shot it out there to the media. He didn't take any questions. And we're going to talk about it because they talk about it in their motion. Just let me know that you can hear it. This is unprecedented in a lot of ways. It's unprecedented during his term of office, and it's unprecedented pretty much. I've never seen anything like this in my 30 years, okay? I have never seen anything like this. Let's talk about it.
The first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Read is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Campton the night he died.
That's what the evidence shows? Don't we have trials for a reason? Counselor, aren't there trials for a reason? How dare you get on national television, international television, in an attempt to what? Influence jurors? Because what you say as district attorney, as an elected public official, is going to carry more weight than anything that a defense attorney says. Common sense. That he says the evidence shows that John O'Keefe never entered the home.
Died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that his phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night.
Wow. Are we trying the case in the media? I mean, this is so much more egregious when I look at it now than when we looked at it the last time, because I don't know why. It's insane. Really? So you're getting out there and you're telling the public, the jury pool in Norfolk County, nationwide, worldwide, that Karen Reed is guilty, in your opinion? Read between the lines here. What happened to the presumption of innocence? I don't know. I'm a constitutionalist.
0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home.
He doth protest too much. Why is he going on public television, without taking questions, by the way, and again, putting Colin Albert in the spotlight? Why is he doing that? Colin Albert was a minor on the night of January 29th of 2022. Why is he putting his name out there again? And then at the same time, he's blasting other people who do. And it's kind of like, I know you are, but what am I? Like, he's doing the same thing that he is castigating the defense for doing. Oh yeah, this is definitely scripted. I mean, you can see him reading from a paper. This is definitely carefully scripted.
John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder.
So he's saying that the defense theory is a false narrative. He is out there as a public elected official, the office who is trying the case against Karen Reed, and telling the public that her theory of her defense is false. Let that sink in. Where have you ever seen this before? Have you seen the district attorney in the Delphi case come out and say that this whole Odinist theory that the defense has is a false theory and it's hogwash, and it's just, no, you don't see this ever.
Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case.
Because you say so? Because you say so?
To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and
nobody's accusing Jen McCabe of murder, as far as I know. What say you?
accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight.
They were not the result of a fight. We've been over this before, and I'm going to say it a little bit louder for those of you in the back. When have you ever seen, you follow true crime like I do, an autopsy report that puts the medical examiner, where the medical examiner writes in the report, this did not happen as a result of this. This person did not die as the result of a motor vehicle accident. This person did not die as the result of a fight. There is no evidence of a fight based on these injuries. You know what else the medical examiner does not say? This person did die from a motor vehicle accident. Right? Doesn't say that, does it? So when you're the medical examiner, who's maybe not very experienced based on the report, and you've got two state troopers standing over you, watching you do the autopsy, because they were in the room, by the way. Is there something like, oh, can you put in there whether you think it was the result of a fight? No, it's not done.
She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
Blunt trauma like what? Like getting hit with what? A baseball bat? That's blunt trauma. Didn't say consistent with being hit by a car. Have you seen the photos? They're not abrasions, they're lacerations. You don't need a medical degree. An abrasion is like road rash. An abrasion is like a rug burn, a scrape. That's what an abrasion is. Those are lacerations.
A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence.
Yeah, you know what else? So she enjoys the constitutional presumption of innocence, but you just went on for a couple of minutes about how she's guilty. And you know what else happened when they convened this grand jury in late May or in May of 2022, because they indicted her on the murder charges in early June of 2022. You know what else happened in May? Chloe disappeared. Chloe disappeared either during the time that the grand jury was happening or right before the grand jury was happening. We know that because we saw an exhibit in court.
Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet...
I just saw a comment fly by. How can they be witnesses if they didn't see anything? That's a great point. How can they be witnesses if they didn't see anything? Witnesses to what? To the fact that Karen did not appear drunk at the Waterfall bar, because that's what every single one of them said. But they're trying to extrapolate back and say that she was at least somewhere between 1.3 and or 0.13 and 0.29. If she was 0.29, she would be crawling. She wouldn't even be able to walk.
Does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
So he's saying that the evidence has her guilty. Isn't that what he's saying? Is that a proper thing for a district attorney to say? What say you, friends in Norfolk County? Is this who you elected to represent your interests?
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs...
Wait, aren't you trampling over Karen Reed's right to a fair trial by making this statement in and of itself? You're doing exactly what you're saying they're doing?
Needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Okay. So there you go on that. And remember that this, my friends, this video was released in August of 2023, well after Morrissey knew that the feds were investigating the investigation. So keep that in mind as well while we go back to the document. It's egregious. And they're going to say that, you know, what the defense is doing is egregious. Because, you know, I know you are, but what am I? There's a transcript of the statement that we just read. The defense goes on to say that Boston 25 News reported on the federal investigation of the Karen Reed investigation in November of 2023. Because they asked for records regarding Ted Daniel filed a request, a FOIA request for all public records seeking any letters, emails, or other correspondence Norfolk DA Morrissey or any member of his staff has sent to any DOJ entity that mention certain people. And then they forwarded that on to the district attorney's office. And so that's what got the media interested in the federal investigation. We're going to fast forward a little bit in this document. The next prong of this argument is that the Norfolk County District Attorney was aware of being investigated. But they did not tell the defense that they knew that there was an investigation into the investigation until December 4th of 2023, when that story aired on Boston 25. So on December 4th of 2023, the Norfolk County DA's office provided the defendant in a notice of discovery all 6 letters that we've been over before on another stream, which evidenced that they knew that there was an investigation into the investigation because Michael Morrissey sent a letter to, among other people, the Office of Professional Responsibility, as well as Joshua Levy. And here is where the argument begins. The Norfolk District Attorney deliberately and egregiously violated ethical and constitutional due process requirements warranting the sanction of dismissal. When I say dismissal, I mean dismissal of the charges here, which would be dismissal of the indictment. When we went over the motion to dismiss the indictment the other day, I told you that this motion was going to be another way of achieving the same result, or hoping to at least achieve the same result. And the argument is this: the Norfolk District Attorney's video statement coming soon after this court denied the motion for a gag order, while specifically admonishing counsel not to engage in the exact kind of public statements comprising the video statement, and the Commonwealth's delayed disclosure of its knowledge of the existence of a federal investigation of the Karen Reed prosecution, and deliberate misrepresentation of its knowledge about that investigation, merit and require sanctions for violating ethical and constitutional due process requirements. Dismissal of the indictments, while a severe sanction, is the only sanction that can remedy the deliberate and egregious violations. The first prong of that argument is that District Attorney Morrissey's video statement, the one that we just watched, requires sanctions. And that is what we went over at the top of the stream, where we talked about it is well understood that the duty of a district attorney is not merely to secure convictions. It is his duty to secure them with due regard to the constitutional and other rights of the defendant. Those constitutional and other rights of the defendant include obligations imposed on the district attorney by the Massachusetts Rules of Professional Conduct. District Attorney Morrissey's video statement violates numerous provisions of those rules, including Rule 3.8, which is entitled Special Responsibilities of a Prosecutor, and Rule 3.6, Trial Publicity, and Rule 8.4, Misconduct. Pursuant to the special responsibilities of a prosecutor contained in Rule 3.8, the prosecutor in a criminal case shall, this is not optional, shall, doesn't say should, doesn't say may, it says shall, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. 1. Refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused and from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 or this rule. And 2. Take reasonable steps to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 or this rule. District Attorney Morrissey's video statement, widely disseminated to the media, clearly violated these requirements. You can make your own judgment on that, but I think that's a pretty good argument. District Attorney Morrissey personally vouched for numerous named Commonwealth witnesses, explicitly stating, in contradiction to the defense theory, that Colin Albert, Jennifer McCabe, Matthew McCabe, Brian Albert, quote, did not commit any crime that night, end quote, and that they, quote, were not part of a conspiracy, end quote, that they, quote, have been forthcoming with authorities, end quote, that they, quote, have not engaged in any cover-up, end quote, that they, quote, are witnesses doing what our justice system asks of them, end quote, and calling the witnesses, quote, these innocent people, end quote. In addition to the civilian witnesses, the district attorney vouched for police witnesses, specifically stating that Trooper Proctor was not part of a conspiracy, was not at the scene where John O'Keefe's body was found, did not plant evidence, and, quote, would have no motive to do so, end quote. All assertions contradicting the defense theory and which the district attorney could not know to be true. Additionally, District Attorney Morrissey's video statement explicitly denigrated the defendant and the defendant's counsel, labeling the defense theories a false narrative, a desperate attempt to reassign guilt, a lie, and contrary to the American values of fairness. In short, District Attorney Morrissey's assertion in his video statement constitute exactly what the Commonwealth alleged about the defendant's counsel statement in its gag order motion, that they go further than zealous representation. They are unsubstantiated proclamations supported only by self-serving speculation and conjecture, likely to not be admissible at trial, and done with the intent of materially prejudicing the criminal proceedings by risking the impartiality of potential jurors. Let's take a breath and go to the chat for a minute, because this is a great argument. It's a great argument, and there's a lot of merit to it, I submit to you. And let's see, what say you? Thank you, Heavy Aller, for 617 for the super chat. You are a great addition to this case. Thanks, Melanie. Thank you. Thanks for having me. Hey, Bill Garks, thanks for becoming a new member. Timmy Heilman, thanks for the super chat. So pretty. Your makeup is spot on. Today's really spot on. Thank you. Thank you very much. Oh, thanks, Galen, for gifting 5 Attorney Melanie Little memberships. That is very generous of you. I appreciate you so. Debbie also gifted 5 memberships. Thank you, Debbie. And Team Brittany, thank you for gifting 5 memberships. In order to receive a membership, you have to be opted in to receive memberships. There's a way to do that by hitting the 3 dots somewhere on the thing. I don't know. Patronus Glow, I know you're here. Maybe you can tell people how to do that. And then YouTube distributes them randomly. I have no say over who gets them. Casey, thanks for your super chat. Big question. What and who has dirt on Morrissey for him to make this statement? I don't know if he got nervous that the feds were getting closer and closer and closer. I don't know. But that is a great question, Casey, and I don't have an answer for you, but we can all hypothesize. Mary, thank you so much for your super sticker, Mary Rothman. And Charlene Savioli, I think it says Savioli, I'm half blind. Thank you for the $20, very generous. What a fabulous Saturday night with Marvelous Attorney Melanie at 7 p.m. and Top Notch Turtle Boy at 9, free Karen Reed. You guys, this is, it's scary stuff, and I've said this before, when Mrs. Coffindorfer said, well, who is Karen Reed anyway? Why would they even want to frame her? That's exactly why. That's exactly why. Karen Reed is you. Karen Reed is me. Karen Reed is everyone. Karen Reed is all of us. And that's why there are so many people that are following this case and that are behind this case, because they believe in justice. They believe in backing the blue, and they believe that there should be justice for John O'Keefe. And for him to get on there publicly and say that the evidence points to it not being a dog attack. And because the I can't even speak, because what the medical examiner put in a report that it was not, he didn't die from a fight. Okay. She didn't say he died from a car accident either. So shield and sword, my friends, shield and sword. And there's some great quotes in here. I have some great merch ideas based on what we're reading here. And this is this is getting a little bit juicy, in my own personal opinion. I'm getting a little bit ahead of myself with my. Okay, I'm going to go to the bottom of page 13 for you. There's just a lot more verbiage about what Morrissey did with this statement was completely, out of line, egregious. He's got his own agenda. And that, if he wanted to make the statement and he wanted to stop witness harassment, his remedy for that was to go after the person who was doing it. And as we know, he did do that. So there was no reason for this statement. Telling the public to stop harassing the witnesses. I don't know. And they say here, nor can District Attorney Morrissey's video statement be justified as having, in the language of Rule 3.8F, a legitimate law enforcement purpose to curtail any intimidation of witnesses in a pending prosecution. Repeatedly during the video statement, DA Morrissey raised harassment and intimidation of witnesses as an issue. DA Morrissey also raised in his video statement the obligation for his own remarks to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. Sorry, we call it Supreme Court here. The vouching for Commonwealth witnesses, the denigration of the defense team were not narrowly tailored to curtail witness harassment and intimidation. The answer to harassment and intimidation of witnesses is to investigate and prosecute the intimidators, not to disseminate an unprecedented video statement vouching for Commonwealth witnesses and denigrating the defense theories. And we know that they did that because in footnote 4, it says that they did that. Indeed, that is exactly what the Norfolk County District Attorney's Office has done. It appointed a special prosecutor special is a great word, who has investigated and brought indictments in Norfolk Superior Court against Aidan Carney, an online blogger known as Turtle Boy, who has covered this case extensively on his website, YouTube, and social media, charging him with 8 felony counts of witness intimidation, 3 felony counts of conspiracy to intimidate a witness, and 5 other related misdemeanor counts. There are no allegations at all that the defendant or the defendant's counsel engaged in any witness intimidation or harassment. Oh, but just wait and hang on to your seats, because that's going to be their entire opposition. They also go on to say that finally, District Attorney Marcy's video statement cannot be justified by the provisions of Rule 3.6e, that this rule does not preclude a lawyer from replying to charges of misconduct publicly made against him or her. District Attorney Marcy's video statement did not raise or address any public charges of misconduct made against him, and the federal investigation of him and his office had not yet been made public. So that statement could not have been made to defend himself against the feds, because it wasn't made public yet that the feds were coming in and investigating the investigation. They also allege that this video statement violated other ethical rules. And it says, this misconduct by a prosecutor is not simply a violation of the rules of professional conduct. It also strikes at the heart of our system of criminal justice, dependent on observation of constitutional due process protections and obligations. It is fair to say that the average jury, in a greater or less degree, has confidence that these obligations, which so plainly rest upon the prosecuting attorney, will be faithfully observed. You can render your own opinion on that. They go on to say that because of all of these reasons, the district attorney, the Commonwealth, should be sanctioned. And then they also say the Commonwealth's delayed disclosure of and misrepresentations about the federal investigation of the Norfolk District Attorney's Office requires sanctions as well. Rule 3.8 of the Rules of Professional Conduct also required that the prosecutor in a criminal case, 2D, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. The DA's office knew for over 6 months that the U.S. Attorney's Office was investigating it, and the Commonwealth's investigation and prosecution of Karen Reed. It knew multiple witnesses involved in its prosecution had received subpoenas to appear before a federal grand jury. It had even confirmed that witnesses testified before the federal grand jury, but did not disclose the extensive correspondence it had with the U.S. Attorney's Office, the DOJ, and the FBI until December 4th, 2023. Compounding its failure to make timely disclosure to the defense of this information it knew about that tended to negate the defendant's guilt, the Commonwealth failed to make any disclosure at all until it was apparent that media outlets had gained the information and would be reporting it. Even when they did disclose it, the defense says they deliberately misrepresented what it was disclosing. When they served their notice of discovery upon the defense, they listed the 6 letters and said, as of December 4th of 2023, the Norfolk District Attorney's Office has received no discovery or information about the parameters of federal activity, nor confirmation about whether any witnesses associated with Commonwealth v. Karen Reed have testified before a federal grand jury. That, my friends, was a lie. They knew, according to these papers. In fact, it knew about the existence of a federal investigation involving a number of witnesses in the defendant's case because the first assistant at the U.S. Attorney's Office had told it so. And further, the Norfolk County District Attorney's Office had, in fact, earlier than May 18, 2023, confirmed that witnesses testified before the federal grand jury. The Commonwealth's assertion in its court-filed notice of discovery was patently false. They go on to cite Brady, saying that they are required to turn over exculpatory evidence. And how do we know that they know that? Because repeatedly in the letters that we went over, they mentioned to the DOJ and the U.S. attorney that we need this information because under Brady, we're required to disclose it. But they never did until December of 2023. In addition, the third prong of this argument is prosecutorial misconduct. And the defense is saying that dismissal of the indictments is the appropriate sanction. Sanction is a punishment. Sometimes it's money. Sometimes it's dismissal of the charges. It's your legal term of the day. They admit that dismissal of a criminal case is a remedy of last resort. Nonetheless, an indictment is the appropriate remedy for prosecutorial misconduct in two different instances. First, an indictment must be dismissed for prosecutorial misconduct upon a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Second, under the alternative principle, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice. In such instances, prophylactic considerations may assume paramount importance, and the drastic remedy of dismissal of charges may become an appropriate remedy. First, the defendant's opportunity to obtain a fair trial has been irremediably harmed by District Attorney Morrissey's extensive vouching for Commonwealth witnesses and his denigration of defense theories in advance of the test of trial. This case, in the words of this court, has generated significant media attention locally and nationally. District Attorney Morrissey knew his video statement, which he himself characterized as unprecedented in his over dozen years as district attorney, would be disseminated throughout Norfolk County, the Commonwealth, and the nation, which in fact it was. His deliberate tainting of the jury pool to such an extent that even a change of venue cannot remedy the local prejudice to the defendant constitutes irremediable harm. This prejudice to the defendant, this harm, is compounded by the Commonwealth's deliberate withholding of exculpatory information known to it about a federal investigation regarding its witnesses, exacerbated by the Commonwealth's deliberate misrepresentation about what it knew about that investigation. How differently would District Attorney Morrissey's video statement have hit if he also had disclosed that the Commonwealth's witnesses were being investigated by the U.S. Attorney's Office? His intent to harm the defendant's case, to influence the jury pool in favor of the Commonwealth, is obvious, and that harm is irremediable. I tend to think that that is a very good argument. Second prong of this argument. Second, DA Morrissey and his office's misconduct was egregious, deliberate, intentional, and resulted in a violation of the defendant's constitutional rights. DA Morrissey DA Morrissey already knew that this court had declined to gag defendant's counsel's statements. He already knew this court has deemed the defendant's counsel's assertions and pleadings in court argument and publicly to be pertinent to the theory of her defense, finding that the statements are therefore permitted under the rules. Most importantly, DA Morrissey had to be keenly aware that this court's order denying the Commonwealth's motion for a gag order had specifically raised the differing special obligation imposed on a prosecutor regarding the defendant's fair trial rights, explicitly cautioning counsel to be cognizant that statements commenting on the character, credibility, or reputation of a witness, or conveying information which counsel knows or reasonably should know is likely to be inadmissible as evidence in trial are more likely than not to have a material prejudicial effect on the proceeding. And soon after receiving that admonition, he disseminated the video statement anyway. Clearly denied his motion for gag order, the DA took it upon himself effectively to silence the defendant, her counsel, her defense theories by using a bullhorn to vouch for the Commonwealth witnesses, to denigrate those defense theories, to call them a false narrative, a desperate attempt to reassign guilt, a lie, and contrary to the American values of fairness. He did exactly what this court cautioned against doing soon after receiving that caution. It was egregious, deliberate, intentional, and resulted in a violation of the defendant's constitutional rights. Dismissal of indictments is the appropriate sanction. This is what we read at the top of the stream. If you didn't see it because you're joining now, you can go back and read it later. Some very, very important, in my opinion, statements. They go on to say that DA's own words, the DA's own words in his lengthy May 18, 2023 letter to the Office of Professional Responsibility at the DOJ reveals that Morrissey's got other interests here about his, that he knew that he and his office were being investigated by the U.S. Attorney's Office, that he thought that that investigation was based on things like Rachel Rollins and a disgruntled employee and was improperly motivated. And they say whether he was right or wrong that that investigation was improperly motivated by animus towards him and his office, he clearly has an interest in the conviction of Karen Reed other than the interests of justice. Her conviction by a jury based on evidence presented in court establishing guilt beyond a reasonable doubt would clearly vindicate him, his office, his investigation, and prosecution of Karen Reed to the detriment of any federal investigation of him, his office, his witnesses. By contrast, an acquittal of Karen Reed would be devastating to him, his office, his conduct of this investigation and prosecution regarding the federal investigation of him and his office. So they say clearly, DA Morrissey has an interest not that justice shall be done in this case, but to win this case. And in addition to that, it's not just the egregious improper video that DA Morrissey released, which was in kind of direct violation of what the court admonished him not to do. Here's all of the ways that they have slow-walked the provision of discovery since the date of the initial arraignment in Stoughton Court and throughout the prosecution in Superior Court. Here, my friends, are examples of discovery material requested by the defense, but only provided by the Norfolk attorney after many months, or not provided at all, including the following. Digital crime scene photographs from January 29th and February 4th of 2022. The defense made a motion to compel digital versions of these photographs, and that motion was allowed on October 5th of 2022. Thereafter, the DA ignored multiple emails and other requests for compliance. Finally, the DA's office notified the defense on May 3rd of 2023, over a year later, over a year after the incident, that the iPhone used to take the January 29th and February 4th photos no longer existed. To this date, no metadata from those photos have ever been provided. iPhone's just gone, folks. Nothing to see here. Crime scene photographs, nothing to see here. No metadata. Next item, confirmation of the preservation of Google geofence data. The defendant's motion for preservation of Google geofence data from all cellular devices was allowed by the Stoughton District Court on April 29th of 2022. On May 13th of 2022, Trooper Michael Proctor, under the command of the DA's office, sent a preservation request to Google that failed to request preservation of any data. Let's start that again. Failed to include the preservation of any data from iPhones. It only requested preservation of all apps downloaded from the Google Play Store, which would only include Android phones. Despite numerous follow-up requests from the defense, the DA's office to this date has not produced any confirmation from Google that the proper geofence data was ever preserved. If you'd like to know a lot more about geofence data, in this case, go to Microdot's YouTube channel, and they did a great video on the geofence data in this case. I highly recommend. And we know most of the people in the house had iPhones. We know that John O'Keefe had an iPhone. We know that Jen McCabe had an iPhone. I think that Brian Albert had an iPhone. I don't know how many Android phones were in the house, but the majority were iPhones. So we do know that now. Inspection of the taillight and housing. The defendant's accident reconstructionist, Carrie Alvino, traveled to Middleborough on May 27, 2022, to inspect the vehicle and to examine the taillight and housing, among other items. When Ms. Alvino arrived, however, she learned that the taillight and housing had not only been removed from the vehicle, but were not produced for her for inspection at all. Thereafter, the defense filed a motion to compel this inspection, which was finally allowed by the court on August 12th of 2022. After access continued to be denied, the defense followed up with further email and other requests, in addition to further motions to compel. It was not until December 1, 2023, that the defense team was finally able to inspect the taillight. December 1, 2023, almost 2 years after the incident. Inspection of John O'Keefe's clothing. Remember the clothing that we saw on the floor in the hospital in his autopsy photos? That clothing that wasn't turned into evidence for weeks after. On May 27, 2022, the defense counsel emailed the DA's office requesting to inspect the clothing that John O'Keefe was wearing when he was found in the front yard, Boston police officer Brian Albert's home, 34 Fairview. This court allowed the defense emergency motion to compel on August 12th of 2022. 3 months later. Thereafter, defense followed up, further email, another motion to compel, and it was not until December 1 of 2023 that they were finally able to inspect the clothing. Again, almost 2 years after the incident did it take to get the basic items of evidence tested when the trial date had already been set for March 12th of 2023. So December 1 of 2024. So 3 months prior to the trial date is when they were finally allowed to inspect the taillight and the clothing. Next item, missing ring videos. On September 15th, 2022, defense filed a motion to compel production of the ring videos from John O'Keefe's home at 1 Meadows Avenue in Canton. The court allowed the motion on October 5th for all videos through January 29th. DA's office ignored that court order, and 2 follow-up emails finally notified the defense for the first time on January 5th of 2023 that investigators had actually obtained a search warrant for the missing ring videos. When the DA's office finally produced the search warrant, however, it was dated January 26, 2023, after the DA's office had told the defense that the search warrant already existed. Nothing to see here, folks. In February of 2023, the DA's office produced a February 10th, 2022 email, allegedly from subpoenas@ring.com, stating that the ring videos had been deleted from Dropbox after 90 days. To this date, the defense has not received the missing ring videos. Next item, all 911 calls, including the complete recording of the call made by Jennifer McCabe. On February 2, 2022, at Ms. Reed's arraignment in the Stoughton District Court, the defense filed a motion for preservation of all 911 recordings. The DA's office produced an incomplete 911 recording on June 10th, 2022. Defense followed up, motion to compel, which was allowed October 5th, 2022. It was only after multiple emails and other requests over several months that the full 911 recording was finally shared with the defense on February 8th of 2023. A year later. It took a year. Next item, identification of an unnamed female witness at 34 Fairview. On September 15th, 2022, the defense filed a motion to compel the DA's office to reveal the identity of that female witness. That motion was allowed by the court on October 5th, 2022. After the DA proceeded to ignore that court order for more than a month, the defense followed up with an email November 14th. They finally revealed on November 21, 2022, that Sarah Levinson was the female's name. Next, preservation of samples from John O'Keefe's arm for independent testing. On February 2nd, 2022, the defense filed an emergency motion in the Stoughton District Court for the preservation of evidence, including DNA, blood, saliva, and other bodily fluids. That motion was allowed by the court on the same day. After numerous email requests and further motions to compel, the DA's office finally revealed in July of 2023, wait for it, that no tissue samples from John O'Keefe's arm were ever taken or preserved. July of 2023, no tissue samples were taken from John O'Keefe's arm. Nothing to see here. We don't need to find out how these lacerations occurred. Next item, Canton Town Library surveillance footage in its original format. On June 10th, the DA's office produced video footage from the Canton Town Library, but key time periods were excised or missing from the footage. Thereafter, defense demanded access to the footage in its original format as received by the prosecution, which was apparently via share file. On October 26th of 2023, the DA's office announced in court that it did not have the surveillance videos in any other format other than the DVD produced for the defense. The key time periods remain missing to this date. Next item, Lexus infotainment and telematics systems. Ms. Reed's Lexus was seized by investigators on January 29th, 2022. When a defense accident reconstructionist, Carrie Alvino, was sent to inspect the vehicle on May 27th of 2022, she learned only when she arrived that the infotainment and telematics systems had been removed from the vehicle. Those systems were not produced for Ms. Alvino's inspection on that date. After several email requests, the DA's office only made those systems available for inspection by the defense on December 1 of 2023. Again, 3 months before the trial date. Next item, all police reports and notes. Same day, February 2 of 2022, defense filed a motion in Stoughton for the preservation of all police reports and notes. The DA's office did not produce any notes until September 29th, 2023. Those notes were portions from the MSP. The DA's office then revealed that notes from the Canton Police Department and the CERT team do not exist. In light of all of these circumstances, in a case in which the district attorney has a clear interest in the outcome of this trial and has clearly evinced an improper intent to influence that outcome, DA Morrissey and his office must be disqualified from prosecution to this matter. And if you don't want to dismiss the indictments, you should appoint a special prosecutor to this case and get him off the case, disqualify him from the case, dismiss the indictments, appoint a special prosecutor, and then let that special prosecutor decide whether more indictments should be forthcoming. An independent, disinterested prosecutor. Because they note here, because that's what you did in Aidan Carney's case. And the conclusion to this motion is, for the foregoing reasons, defendant requests this motion be allowed. All the indictments in this matter be dismissed as sanctions for prosecutorial misconduct. That alternatively, all the indictments in this matter be dismissed as part of the disqualification of DA Morrissey and his office, and that DA Morrissey and his office be ordered disqualified from further investigation or prosecution of this matter. I happen to think there are some very, very good arguments there. So let's go to the chat for a minute so we can see what say you. Is my favorite part. When I'm reading to you, I can't see the chat moving. So we're going to go back here now. Uncle Fredo, thank you for your super sticker. TW72 became a new member. Congrats. Uncle Fredo, thanks again for another super chat. Know that there is video of Kevin Albert's car leaving his house at 1:30 and returning at 5 a.m. and he drives a Ford Edge. We know that. We know that. You know how we know that? We know that. Thank you, Uncle Fredo. But we don't know. I don't know that video. But I do know that that they own a Ford Edge because there was a ticket that we went over on another stream that Colin Albert received at his college And he was driving a Ford Edge that was registered to his mom. Thank you, Shauna Banana, for being a member for 2 months. Does he want justice or just to be right? Poor John O'Keefe. Melissa Smith, thanks for your super chat. For anyone late, be sure to listen to the due process clause of the U.S. Constitution that Melanie reads about 5 minutes into the stream. Isn't that incredible? And also what the Chief Justice said, I thought was incredibly insightful. And this is what we need to understand as public citizens of this country, what we're entitled to under the Constitution. Thank you, Lizzie Dalton, for your $10. If I ever need a lawyer, I would want you. Thank you. Thank you so much. Oh, and that reminds me, there are a lot of people reaching out to me via various methods, like Instagram messages, which get thrown into a black hole and I never see because they're like hidden somehow, and trying to like reach out to me, asking for legal advice or asking me to represent them. I just can't do that. I don't give out legal advice on this channel. Everything I say is commentary. I am not taking on any clients right now. So as much as I would love to help you, I just can't. So I hope you understand that. Thank you, Lizzie, for that. Michael Calagiro, thank you for your $10. Consider case is unwinnable. Michael Marcy's public statement breaking all the rules is a roll of the dice. Worst case, judge tosses case. Best case, he gets to insult defense with conspiracy theorist label. Hello, Amy in Boston. Thank you for your super chat. So much love and respect for you. Thank you. Thank you. Thank you. Thank you so much. I appreciate you guys so much. So much. This is a labor of love here. You know, it's basically a voluntary position. I don't need to beg you for food money. I know there are some, sometimes I look at Reddit, not often, but there is a very interesting Reddit thread about me that says, and it's on another creator's a thread. So I'm not going to mention anybody because I'm not going to bash anybody here, but it says what we love about Melanie Little, she doesn't beg for money. So thanks for thanking that. Of course, everything is definitely appreciated 100%. But I will never beg you for money, and I will never make you pay to have your comment read or to be to enjoy this channel. Subscribing is free. It helps the channel. Liking the video is free. Sharing the video is free. All of those things help the channel. If you shop on Amazon anyway, you can shop through my link for anything. It doesn't even have to be stuff that's on my list. It doesn't cost you anything, and it helps the channel. I mean, listen, I have Amazon coming to my house like 3 times a day. I order everything from Amazon. I mean, everything. Cat litter, like what I would so much rather not go to the store and just have Amazon come, and I do. So I know that you guys do it too. Thank you, Patronus Glow, for putting the link in the chat. You can buy anything through my link, all the stuff that you would normally buy. If you just go through that link right there, it helps the channel. They send me like, 5 cents a month, and it helps. Hello, Peter Pranzo, one of my amazing mods. This case has a messy and slanted appearance. Must be given a thorough cleansing to achieve justice. Yeah, like a high colonic, Pete. A high colonic. Peter is also retired law enforcement from NYPD. And so we greatly respect all of his opinions. And his wife, Rochella, is also a moderator. And Rochella, thank you for the cupcake towels. Oh, they're all the way over there. Otherwise, I would show them to you. Rochella was amazing. She brought me some cupcake towels that she saw on her vacation while she was away and thought of me. And that was so, so sweet. Thank you guys. Thanks, Pranzos. You guys are amazing. Kirks, 71. Chris Albert is Colin's dad. He has a hotline to Mello and Marcy, and even has a police officer at select board meetings, even though he doesn't pay his taxes. Lied to get business license equals perjury. Well, no. I don't know. You don't support businesses when you buy Amazon. I mean, I shop locally too. I do both. For me, it's more about convenience because I'm so busy that I just don't have time to go to the store. I'm sorry. There also is an Amazon warehouse right here on Long Island. So all those people are employed in the warehouse. There's a lot of people employed there. So I am helping to keep my fellow citizens in my area employed. And there's still an employment problem. And anybody who's telling you otherwise is lying to you. Susan Baker, thank you for your comment. Are there autopsy photos of the other side of John O'Keefe's arm that would show that a dog had latched onto the arm with his teeth? I have not seen the other photos, but I will tell you this. And I cut down a shorter version of the episode that I did with canine master trainer Garrett Wing. And I put it up unlisted because it was immediately demonetized as being not friendly to advertisers. I'm waiting for it to for my appeal to be granted before I publicize it. It's about a 29-minute video. It's like portions of the episode that I already did. I would suggest to you that you go watch that episode, because this canine master trainer who has been training police dogs for over 22 years, teaching dogs how to bite, explained to us why a dog who is untrained, especially a German Shepherd, will not always clamp on to its victim. Oftentimes what happens is they have shallow bites, which you never try and think of a word and you can't think of the word, which result in re-engagement of the bite. And that's why on an arm, you may see a lot of lacerations. And the reason they look like lacerations is because the force of a dog's jaw, especially a power breed like a German Shepherd, the force of their jaw is so great. And then it's your natural instinct to try and pull away. So while the dog's bearing down on you and you're pulling your arm away, that is how lacerations are formed. And that if it's a shallow bite, sometimes they will only bite with their top two teeth. It's more like a scrape. But go back and watch that video because it's really enlightening. Anybody who's watched it, you can chime in. It's really enlightening about dog bites. I mean, this guy has seen hundreds and hundreds and hundreds of dog bites and written dog bite reports, and teaches dogs like German Shepherds how to bite. And he even says in this video that the hardest thing to do when you're training a dog, and they use German Shepherds for police dogs all the time, is getting the dog to bite human flesh. But once they get their first bite, then they will bite all the time. So that's really interesting. It's fire. Yeah, that's a great video. Yeah, so go back and watch that, I suggest. There's a lot of, you can fast forward through parts and you can see where we look at the autopsy photos and he gives his opinion on the autopsy photos, and he sent them to two friends and he knew nothing about the case when I contacted him to come on the show. And one of my amazing mods had sent me one of his videos of a German Shepherd that he was teaching how to bite. And he had this sleeve on his arm and the bite was ferocious. It was crazy. And I contacted him to come on the show. He didn't know anything about this case at all. And he sent that, photo to two of his friends who have been training dogs for 20, 30 years. And he said immediately, no question, absolutely 100% dog bite, no question. All right, let's get through the opposition on this before we have, what time is it? 8:25. We've got about 35 minutes. So here's their opposition. And their opposition is a whole bunch of, I know you are, but what am I? Nanny, nanny, poo poo. Nanny, nanny, poo poo. This is basically, I'm going to say, a stunning display of smoke and mirrors, my friend. A stunning display of smoke and mirrors, and with a little bit of Aiden Carney thrown in there. And it is, they do not address at all their failure to turn over all of that evidence that we just went through, which really makes me angry, because the 911 call is a basic item of discovery that is in their possession immediately upon arraignment. For them to wait however long to turn that over is inexcusable. There's really no excuse. And basically what this motion is all about, in a nutshell, is this is a battle of ethics. It's a battle of ethics and misconduct. And they're going to turn around and say, well, we didn't just violate any ethics. It was the defense who violated the ethics first. And they're not allowed. They talked to the media and they said all kinds of stuff. And even like, now, judge, you should grant us a gag order now, because look, it's getting closer to trial. And they're talking to people. And then they ask for something incredibly baseless at the end of this motion, which is really something that I've never seen before and kind of shocked me to my core. So what they say basically in their opposition is they restate, what the defense is looking for here, which is that the indictment should be dismissed because of DA's video statement 6 months ago and a purported delayed disclosure, about an investigation being conducted by the feds. Defendant's claims are misleading and disingenuous as they are premised upon the defendant's misrepresentation and actions knowingly made to deceive this court and undermine the integrity of the judicial proceedings. Do you see that mention anywhere in there? They're delaying turning over the evidence. They don't even mention it. But here's what they say. Over the past 2 years, evidence sought by and presented to the Commonwealth has not shown any credible evidence that another individual is responsible for John O'Keefe's death. Okay. Did you look for it? Did you even look to see if there was any evidence of someone else committing this crime? No, you didn't. You didn't look for it. They say what began as Attorney Yannetti representing to the Stoughton District Court in February 2022 that the defendant lacked any criminal intent in a motor vehicle accident has spiraled into a national conspiracy theory premised upon the defendant's variety of flawed, unfounded, and sensationalized claims. However, truth is not dictated by the loudest voice. Let's remember that for a t-shirt. Truth is not dictated by the loudest voice. Who's the loudest voice so far in the room here? Anyone? Anyone? Bueller? Who? That's so funny because somebody said Spicoli. Somebody's name is Jeff Spicoli. Sometimes you have to close YouTube to fix the sound. Says True Crime Junkie, the OG. Truth is not dictated by the loudest voice. Then they go on to talk about Morrissey's August 25th recorded statement. In response to an extraordinary degree of relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22, 2023 rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers, on August 25th, 2023, District Attorney Morrissey released a recorded statement that cautioned against the improper and unlawful harassment of witnesses. I submit to you, my friends, that this was not Karen Reed's doing. It was not her making. It was not her attorneys doing or making. This was a rolling rally of interested citizens who are looking for justice and who are standing up for possible corruption in their hometown. This is smoke and mirrors like you've never seen. They are going to throw spaghetti at the wall and talk about all of this stuff that Aidan Carty may or may not have done, may or may not have reported on. None of this stuff, in my opinion, has anything to do with the defendant or her counsel, and all of this is fluff. It's fluff, my friends. They say that he was well within his right to make this statement, that the rules permit an attorney to make a warning of danger concerning the behavior of a person involved, and when there's reason to believe that there exists the likelihood of substantial harm to an individual or the public interest. They're saying that this is a statement necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. They're going to go on and on and on with a lot of stuff that doesn't make a whole lot of sense. That the DA's statement. Oh, here. Oh, this is interesting too. They're going to say, the DA's statement was only 5 5 minutes and 45 seconds long. But when defense counsel and the defendant went on Dateline or Nightline or whatever it was, that was 9 minutes. So really, we're not as bad as they are, because theirs was 9 minutes and ours was only 5 minutes and 45 seconds. So, you know, we didn't really do anything wrong. And they say that DA Morrissey's statement was made in response to an August 22, 2023 ABC News broadcast where Attorney Jackson, Attorney Yannetti, and the defendant sat down for an interview with ABC News Chief National Correspondent Matt Gutman. During this 9-minute and 37-second segment, videos of the Free Karen Read protests were shown, photographs of witnesses displayed, and the defendant made numerous comments about the evidence and her relationships. When asked what the defense believes to have occurred, Attorney Jackson passionately asserted, quote, pieces of taillight evidence were planted after the fact, end quote, and that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical and he was beaten to a point of unconsciousness. See video beginning at 7:50. Attorney Jackson then commented about his impressions of the victim's injuries, including a claim that the victim had defensive wound bruises on the back of his hands. Attorney Jackson continued on to ultimately declare, without an indicia of proof and substantial evidence to the contrary, this was a cover-up. John was murdered inside that house. His body was placed outside. How do they know what evidence the defense has? How do they know? He's well within his rights, defending his client, to make statements such as those. Nothing wrong with that. Karen can talk to whoever she wants to talk to. Her attorneys can talk to whoever they want to talk to. And there's nothing inappropriate about that. But they're going to go on for 25 pages and try and spin this into some sort of a theory to try and convince the court otherwise. That they continue to give statements. Oh, and here's a good one. Defendant and counsel have continued to give numerous interviews with local and national media outlets where they make unfounded and inflammatory statements about witnesses' character and reputation, repeatedly describe the Commonwealth and its investigators as corrupt. And on September 15th of 2023, Attorney Jackson made a comment to the media in response to District Attorney Morrissey's recorded statement, where he seemingly attacked the intelligence of District Attorney Morrissey by stating, quote, so listen up, sir, and I'll speak slowly so you understand. Michael Morrissey, we ain't got no quit. Insulting his intelligence? I'm sorry, did he hurt his feelings? Are we really putting that in our papers now? Smooth as butter, Alan Jackson hurt my feelings, Your Honor. Insulted my intelligence, and therefore I had to go on TV and give this statement. Or, I don't remember which was first, but in any event, it's like finger pointing to the nth degree. You hurt my feelings. And here, the defendant's continued attempts to materially prejudice the judicial proceedings and to try the case in the media is unprecedented, further supported by the fact that on September 17th of 2023, the defendant traveled with Attorney Jackson, Attorney Little, no relation, and a woman believed to be a television news producer to the victim's home in violation of her conditions of release, as well as other places of interest in Canton. Ooh. Ooh. When balanced by the amount of public and prejudicial statements made by the defendant and her counsel, the suggestion that District Attorney Morrissey's statement from over 6 months ago threatens her right to a fair trial is untenable. Because they made more statements than I did, Your Honor. So therefore, that's kind of ridiculous. And you shouldn't dismiss the indictment, and you shouldn't say that I'm prosecutorial misconduct, because they made more statements than I did. Unfortunately for him, the DA is held to a higher standard than defense counsel. And the reason that you don't see a lot of defense counsel out there zealously representing their clients is because most high profile defendants in criminal cases are represented by public defenders who don't get paid a lot of money. These are private defense attorneys, and that's why you're seeing such zealous representation. You know, these are attorneys that have media connections, that know how to handle the press, that know how to handle a press conference. No disrespect at all to public defenders, because they do an amazing job, and they work practically for free a lot of the time. But they're not as savvy with the media as private defense attorneys are. It's just true. But should she be prejudiced for that? I don't think so. What say you? And so the gag order was never granted, as we know. And again, it's basically like a "you hurt my feelings" defense. Any statements by a public official certainly carry more weight than any defense attorney. They go on to say that, they knew, defense knew about the federal investigation because allegedly somebody told Aidan Carney about it, and they're going to consistently allege that it was either Karen or her attorneys who told Aidan Carney about it. And they're going to go on to pages and pages and pages about communications between a third party who was allegedly relaying information to Aidan Carney, who, by the way, is a journalist. I don't know, what the definition of a journalist is, but if you're a blogger, that, there's no license required to be a journalist. Okay. So somebody who publishes 200 and something stories about a case, I would submit to you, is probably a journalist. So let's go to see where most of my notes are. Okay, page 9. The Commonwealth has diligently investigated the defendant's unsubstantiated allegations of police and prosecutorial misconduct. Efforts to disprove the defendant's allegations have included interviewing additional witnesses, submitting evidence to a veterinary forensic laboratory that concluded there was no canine DNA associated with the swabs taken from the victim's clothing in the areas of the victim's injuries, the voluntary submissions of law enforcement officers' DNA profiles to conduct comparative analyses, extensive GPS analysis of the victim's phones, physical locations at various points, and the hiring of 2 independent forensics examiners, one of which is the senior digital intelligence expert from Celebrite, to explain how the defendant's supposed expert misinterpreted the Celebrite data from Jennifer McCabe's cell phone records, confirming that the internet searches that we've been over 100 times were definitively conducted at 6:23 and 6:24 a.m. when the defendant, Carrie Roberts, and Ms. McCabe were together on Fairview Road following the discovery of the victim's body. All of these measures were taken by the Commonwealth to acquire any exculpatory evidence and to safeguard and protect the integrity of the judicial system, not subvert it, as the defendant has claimed. Okay, really? You're out there looking for exculpatory evidence in your diligent investigation? This investigation was the furthest thing from diligence since Jump, since Leaf Blower, since Solo Cups, since No Crime Scene Tape. But you're going to submit to the court that you've diligently investigated the defendant's unsubstantiated allegations by interviewing additional witnesses that you never interviewed in the first place, that you should have interviewed, but you didn't. Good on you. Submitting evidence to a veterinary forensic laboratory that concluded that there was no canine DNA associated with the swabs taken from the victim's clothing in the areas of the victim's injuries. That's a loaded sentence. And you will recall that no tissue samples were taken from his arm. So when they say the areas of the victim's injuries, which areas are they talking about? They're talking about from his baseball cap that wasn't found until how long after his body was found? Because there was an injury to the back of his head. Which clothing are you talking about? What areas did you swab? Why didn't you swab his actual arm? And the clothes didn't get into evidence until, I don't know, what, 4 weeks later? Did anybody wash the clothes? I don't know. Did the clothes have blood all over them? Were his clothes changed? Somebody said his clothes were changed. Did his clothes have, was his right arm of his shirt shredded? Because it should have been based on the injuries. So, while the other side is making a lot of this, I want to see what this actually is. What clothing? What area? If the clothes were outside in someone's trunk or in a washing machine, would there still be any canine DNA on it? I don't know. Yeah. The later search shows as the later searches happened. Forget about the first. Clothes were thrown on the hospital floor. That's right. That's right. Shelby says, areas all over there once they picked his clothes up from the hospital floor. Did anybody throw them in the washing machine? I don't know. The later searches happened. We're not going to mention the first search. Right. Mm-hmm. Quincy Chick. Hey, Quincy. I like how you spell Quincy phonetically. That's great. They either washed his clothes or changed him. Vomit only on his underwear. Yeah. So was the shirt all bloody? I have questions. I have a lot of questions. You can just make that blanket statement here because you knew when you filed this that you were not filing it under seal so that everyone was going to glom onto this one sentence. When did you submit it to the veterinary forensic lab? When did you do that exactly? Where's the geofence data? Where are the Google searches? You talk about hiring an expert to go over Jen McCabe's cell phone records, but where are the Google searches? Where's the geofence data? That could be exculpatory. We don't have that. Then, as we get to page 10, they are going to now request another gag order or a gag order. They're going to request a gag order again because they're saying Attorney Alan Jackson, Attorney David Yannetti, and the defendant have knowingly engaged in conduct to undermine the integrity of the judicial proceedings, and the Commonwealth requests that this court revisit whether there should be an order as to prohibit extrajudicial statements to protect the right of a fair trial for all parties. Because they filed defense motions that were knowingly made to deceive the court and undermine the integrity of the judicial proceedings. And then they laughingly, following an investigation conducted by a special prosecutor, you know who the special prosecutor is, right? They call him Mellow Yellow. The Commonwealth has recently learned that for months, the defendant, Attorney Alan Jackson, and Attorney David Yannetti have secretly conspired to perpetrate fraud upon the court through reckless mistruths, deceit, and hiding behind a social media blogger who has been criminally charged with intimidation of witnesses to direct and encourage the harassment of these witnesses. Those, my friends, those are fighting words. Those are fighting words because you're coming out and you are directly accusing defense counsel of some pretty serious ethical and perhaps criminal allegations. You learned that through your special investigator, your special prosecutor, Mello, told you all this stuff? Secretly conspired to perpetrate a fraud. Okay. So again, now they're going to go on for another, I don't know, something like 10 or 11 pages, all about Aiden Carney. Let's shift focus. Look, don't look there. Look over here. This is interesting. For months, the defendant and counsel have engaged in a concerted effort to use Mr. Carney as a literal bullhorn to say what they could not and to disseminate information and opinions counsel knows will have a substantial likelihood of materially prejudicing the proceedings. Is it possible that a journalist could have other sources and obtain information other ways besides being fed information from the defendant and defense counsel? Because let's face it, his involvement, Aidan Carney's involvement in this case did not even begin until April 17th of 2023, as admitted right here by the Commonwealth. And they go on to talk about all of these phone calls between a third-party intermediary, who I think has been Natalie something, who has been given immunity, I think, in this case, and how as of Valentine's Day of this year, TB Daily News has over 291 posts pertaining to the Commonwealth's case against Karen Read. Okay, so what? What does that mean? Somebody who wants to report on this case and is passionate about it, I would submit to you. And in addition, they go on to talk about how there are calls between, there's 29 calls allegedly that they say in their papers here on page 13. Did I go past page 13? Yeah. Call detail records from Mr. Carney's phone also revealed that phone numbers associated with Attorney Yannetti and Attorney Jackson communicated with Mr. Carney at least 29 times. 29 times between April 20th of 2023 and May 2nd of 2023. Attorney Yannetti's phone number had 9 calls with Mr. Carney. And between April 20th and May 1st, Attorney Jackson's phone number had 3 calls with Mr. Carney. You know how many times as an attorney when I was handling the Catholic Church cases for all of the abused victims of clergy SA on Long Island back in like 2002 for however many years. You know how many phone calls I would get from journalists asking for comment? Is it possible that he was calling the attorneys for comment? Like, this is so ridiculous that it's a whole basic, let's pull focus and let's just throw a whole bunch of stuff at the wall that has nothing to do with Karen Read. But, you know, you can try and make everybody think that it does. Because, and this might be my favorite quote of the whole paper. But what happens in the dark always comes to light. Another t-shirt idea. Let me write that down. What happens in the dark always comes to light. And then, in my opinion, these papers actually go on to bolster the defense case, which I don't think they meant to do, because that quote alone, what happens in the dark always comes to light, may turn out to be better for another side. Let's just say. They go on to call the defense firm and Karen enablers of Mr. Carney. Other pieces of prior to making the directive. Wait, where is this? Attorney Jackson, Attorney Yannetti, and the defendant had all communicated with Mr. Carney and provided him non-public materials, theories of defense, and other pieces of evidence that enabled Mr. Carney to harass and intimidate witnesses. Those efforts were encouraged and celebrated by Attorney Jackson on the courthouse stairs immediately following Attorney Jackson. Attorney Yannetti and the defendant hosted Mr. Carney for lunch in the Boston Seaport. Okay, so what? So they bought a reporter lunch. Big deal. I've done that. I would suggest to you that most attorneys had. But instead, what they go on to do is impute all of the actions of Aidan Carney onto Karen Read and her defense firm And in my opinion, that is completely improper. And that's why they tried to they did seize Karen Reed's phones under the guise of Aidan Carney's case. Attorneys give statements to reporters all the time and comments. Then they go on to say that they are not in no way prejudiced by us not telling them about the federal investigation because they knew about the federal grand jury investigation and they publicly revealed it in court on May 3rd of 2023 because guess who wrote about it? And then they go on and on for more pages and pages and pages, all about everything. This is all about Aidan Carney. This really has nothing to do with Karen Reed other than they are trying to impute his actions to her, which I suggest to you is a way to pull focus from the actual facts of this case. Because he may have been calling them for comment. And here they say on May 5th, where is this? On May 5th, they say that Karen may have been in contact with Carney and that she boasts that acting U.S. Attorney Joshua Levy doesn't typically prosecute. Like he never prosecutes. He just delegates to the assistants within the division, but he's running this grand jury. So they characterize that as boasting. Then they go on to talk about a lot of hearsay. And then at the very end, they ask this. They bring Scanlon into this in the end, if you haven't read it. And then in conclusion, there's a lot in here about Aidan's posts. So they're giving him lots of publicity. And they say, contrary to the defendant's representations, the Norfolk District Attorney's Office has no bias or prejudice towards the defendant or personal stake in the outcome of this prosecution. Oh, really? Because that video statement shows otherwise. And except in these papers, you are actually accusing the defendant of witness intimidation by proxy. As in any criminal prosecution, the Norfolk District Attorney's Office is motivated by what the evidence has shown and the interests of truth and justice. The interests of truth and justice, that's what they're interested in. Okay. In conclusion, defendant's motion should be denied. We did not engage in any prosecutorial misconduct. We ask that you now engage a gag order because we don't think that the attorneys should be allowed to speak to anyone anymore. And the danger of publicity surrounding pretrial hearings is particularly acute because it may be difficult to measure with any degree of certainty the effects of such publicity on the fairness of the trial, and unrestrained judicial statements could influence public opinion and inform potential jurors of information that is factually incorrect or wholly inadmissible at trial. Oh, you mean the stuff that could be wholly inadmissible at trial, such as, let's say, things like Karen kissed Higgins in the garage, or Karen and Higgins were texting and we have printouts of them. And Higgins didn't even testify in front of the grand jury, by the way. That was some other people testifying as to what he allegedly said. And as such, perhaps the other text messages and statements and the sisters in Aruba, how about that? All that stuff that may not be allowed into evidence, yet you're publicly filing it, like that kind of stuff. Is that what you're saying? Okay, good. Got it. Got it. And here was another weird thing. During a September 15th, 2023 hearing, defense counsel acknowledged that national publicity will only intensify as a trial date approaches, where, as stated by Attorney Yannetti, in his opinion, he boasted that defendant is the most infamous criminal defendant in America. Is that a flex? Boasting that? Do you think Karen Reed is more infamous than, let's say, I don't know, Koberger, Lori Vallow, the Long Island serial killer, the Delphi killer? I don't know. Further, immediately following this court setting a trial date on September 15th, Attorney Jackson stated to the media, "I can guarantee you that Karen Reed and her family will never, ever quit. Not until the truth comes out. Not until John O'Keefe's killers are brought to justice." As if that was something improper that he should not say. But perhaps the craziest part of this motion comes in on the last page. Oh, they cite the Whitey Bulger case there too, which is interesting. Here we go. Get ready for it. Buckle up. Furthermore, the defendant has previously scoffed at the Commonwealth's absurd efforts to preserve her rights to a fair trial and has claimed that the Commonwealth seems to be arguing that it knows better than Ms. Reed's legal team how to best preserve her right to a fair trial. The Commonwealth does not claim it knows better than the defense team. However, based on the full picture of representation presented before this court, the Commonwealth has genuine concerns about possible post-conviction claims premised on a defendant's claim that Attorney Yannetti and or Attorney Jackson were ineffective for violations of the Massachusetts Rules of Professional Conduct and for what the Commonwealth can only assume to be radical, tactical, strategic decisions. The Commonwealth has genuine concerns that after this case is over, Karen Reed is going to claim ineffective assistance of counsel, and they're trying to prevent that. That's what they're saying here. And then they're saying, therefore, the Commonwealth respectfully requests this court engage the defendant, Karen Reed, in a thorough colloquy about her rights to effective representation. And should the defendant wish to proceed with Attorney Yannetti or Attorney Jackson, a clear finding that the defendant waives any legal claims challenging the assistance of counsel. They want her to waive her right, waive any legal claims to ineffective assistance of counsel in this case at any time, even post-trial. Has anybody ever seen anything such as like that? Where are my fellow attorneys in the chat? Have you ever seen that? They want the judge to give her a colloquy on ineffective assistance of counsel? Really? And then make sure that she waives her right? Waives any legal claims to ineffective assistance of counsel? It strains credulity, my friends. It strains credulity. Thank you, Jeffrey, for your super chat. Is this the United States? How is this allowed? Thank you, Charlene. You are so sweet. Thank you for your super chat. You truly look like the beauty Michelle Pfeiffer. Oh my, I only wish. Thank you, though. Thank you. Will you make I Am Not a Cupcake t-shirt? Kevin Albert is Colin's uncle and is CPD, also drives for it. Yeah, I Am Not a Cupcake. The logo that I had was not great. Didn't show up great on the merch, so I'm going to do it again. Jody Mitchell, thank you for your super chat. These townies totally underestimated Karen Reed. Would have loved to see their faces when they realized she had hired the dream team of Jackson and Yannetti. Yep. Stephanie, thank you for your super chat. What are the odds Bev will make a fair decision? What say you, my friends? What say you? Michael, thank you so much for your super chat. Melanie, you went to law school. Are hand holding and foot rubbing in the same class? Kissing seems upper level. Am I wrong? Yeah, I don't even know how to respond to that, but yeah, the whole thing is bizarre. And Kirk says 365 times Aiden was mentioned in that counter motion, yet it's Karen's murder case. You just cannot make it up. They spent more time silencing Aiden than looking for Fort Edge. And that reminds me, I'm going to teleport you guys over there because I think his show is at 9, right? Is the show at 9? Because that's the right thing to do. His team It's very kind to me. So hang on a second. Let's see how we do that. Come on now. Why is Google asking me to sign in again? What? Stop. What say you, my friends? What say you? Okay. I don't know when the date for this motion is. Does anybody know when this motion is going to be heard? Yes, Melissa, it is a wild ride. It's a wild ride. Thank you all. Thank you to my moderators for keeping the chat classy tonight. Thank you all for dealing with my very, very fast reading skills. And, I went to Evelyn Wood speed reading. Does anybody remember that? Evelyn Wood speed reading? Yeah, the whole thing does seem pretty sus. Please hit the like button before you teleport, kids. And thanks for coming. Thanks for playing. I hope you have an awesome day. We may do a members only tomorrow. So hit all notifications when you hit subscribe, hit the bell. Make sure that you are subscribed. It's free. It helps the channel. Thank you to my moderators for keeping it classy tonight, because I know this can be a rough crowd when we get some people in here that do not, that are not very nice. To all my viewers, my replay viewers, I love you. Thank you. Without you, I would not have a channel. Remember, everyone, be cool, be kind, be classy. I'm not going to teleport you over to Turtle Boy Live for his stream tonight because he just got out of jail yesterday. So go on over there and check it out if you want. Thank you. I'll probably see you tomorrow on something else. Maybe we'll do a members only. It's the full moon. I like to do it on the full moon. Thanks, you guys. Peace out.